Okay. Welcome, everybody, to the 2022 Code Amendments meeting of the Cobb County Planning Commission. Our Senior Associate County Attorney, Brian Johnson, will lead us in the Pledge of Allegiance.
Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, so at this time, our Head of Community Development will introduce the 2022 Code Amendment suggestions or proposals to us.
Yes. Good evening, everyone. Jessica Gwynn, Cobb County Community Development Director. As the chair said, this is the 2022 Code Amendments to Chapter 134. So the amendments that we're dealing with tonight are all specific to the zoning ordinances. That's the section of the code that is within the purview of the Planning Commission. So we'll just jump right in. I'll hit the highlights, and I'm glad to answer any questions that the Planning Commission may have afterwards. So the first section that's proposed for amendment this evening is section 134-1. This is the definition section of the code. There are a few things that we're trying to achieve here. The first is dealing with automobile brokers. Automobile brokers are an office use that's really regulated by the state. It's not something where there would be cars, vehicles for sale on the property. It is strictly an office use, and we currently don't have a definition of automobile broker in the code. So this would add that definition, and it would also add automobile broker offices to the definition of other consumer goods and services. Another thing that's addressed here is clarifying vehicle weight for business vehicles. This is something that Code Enforcement recommended, just to clarify that the vehicle weight is gross vehicle weight for the sake of identifying business vehicles. A couple of other related changes here deal with semi-permanent cosmetic makeup practitioners. Again, it's a use that we don't currently have in our code. It's sort of a newer use, and as discussed in the work session today, it's, again, semi-permanent tattoos like the eyebrow microblading and that sort of things that are really more of a cosmetic type service comparable to other cosmetic services that you may receive versus a more traditional tattoo studio. So adding a definition for a semi-permanent cosmetic makeup practitioner into the code, as well as making sure that that's included within the community retail uses and the neighborhood retail uses. And then the final amendment that we have to 134-1 is to remove the definition of poultry. And as the chair will recall from his time here on the Planning Commission in 2020, we did an amendment to the code to allow for backyard chickens by right and on properties greater than 80,000 square feet. Whenever we did that, there was some conflicting sections that were not removed or changed at that time, and one of those is the definition of poultry. So we'll be taking that out here because that is now addressed in 134-290. Moving right along again, 134-7. This is the section that previously regulated poultry in the zoning ordinance. Again, this is another section that when the code amendment was done in 2020 to allow for backyard chickens by right, there were some conflicts between this section and the new section, as well as there was a lot of duplication. So the standards that are in 134-7 are also included in 134-290. This is a section that really should have been removed at that time. So it's, again, just a cleanup item to clear up duplicative language and also conflicting language. 134-121, we had a lot of good discussion about this in the work session today. And this is a section that determines what's required whenever an application for rezoning or a special land use permit is submitted to the county. Currently, there are requirements in there for traffic studies to be submitted for projects meeting certain thresholds. Currently, those thresholds include properties with more than 75 residential dwelling units or 50,000 square feet of non-residential building space. What's being proposed at this time would be to change that so that it's based on the number of vehicle trip ends that are generated in a single day versus the square footage or number of units. So what's being proposed is 1,000 vehicle trip ends during a single day and or more than 100 vehicle trip ends during a single hour. And as we discussed at the work session, the DOT director, Drew Ressler, said that for a single family, that would typically be 10 trip ends per day for a single family unit. So that would be 100 units. And we had some discussion during the work session today about perhaps looking at doing 750 vehicle trip ends per day or more than 75 vehicle trip ends per hour for a single hour. So that's included and something that you all can discuss in your discussion if that's something that you would like to amend as we move this forward to the Board of Commissioners. The Cobb DOT director would determine the scope of any traffic impact analysis that are done for zoning and also SLUP applications. And then the other thing that I think is really key here is that it would add a requirement that the traffic study has to be submitted. It's got to be completed and submitted to us at least 30 days prior to the Planning Commission hearing. As you all know, we frequently have traffic studies that show up a week ahead of time, and it doesn't give DOT adequate time to review and to provide comments and feedback on that. So this would enable the zoning manager to continue a case that does not meet that 30-day deadline, push them off another month so that we have adequate time for staff to review the traffic analysis. 134-127, appeal of rezoning decisions, and this removes some language in the code that is inconsistent with the way things are currently done, and the county attorney's office elaborated on that in the work session today. Currently, the code says that the appeal should be a de novo determination of the decision before the judge of the Superior Court without a jury. We're scratching that language, and in accordance with a ruling made by, I believe, was the Superior Court. So, and then 134-162. This is another cleanup item. Currently, the code says that commencing April 4th, 1996, new applications for rezoning to the RA6 zoning district will be accepted by the Board of Commissioners. That was done in 2000, or was done years and years ago, but since about 2012, the county has allowed for application and for rezoning to RA6. So again, just removing that language to reflect the practice that actually occurs currently. 134-203.2, this pertains to RSL, residential senior living, non-supportive residential units. For properties that are on a collector road with a minimum of 10 acres and maximum density of 4 units per acre, it would allow for that. This is something that is addressed in another section of the RSL code, so ultimately it's making this language consistent with the language in the other portion of the code addressing RSL. So again, another cleanup item here. Section 134-221.2, the redevelopment overlay district, and this is another item that we had some good discussion about today in the work session. What's being proposed here is to remove the section pertaining to the redevelopment overlay district, or ROD, from the code entirely. As you may recall, in 2021 with the code amendment package, at that point, we stopped accepting new applications for ROD, so no longer could anyone apply for the ROD classification as of March 1st of last year. But this is a commission proposal to remove that section of the code entirely. And as you'll recall, we had a property, the former Sprayberry Crossing site, that was recently zoned to have the ROD overlay district applied. It was approved by the Board of Commissioners last year, and so we do have one site currently in the county that does have that ROD designation that would still be held to this code, to the ROD code, as well as to the zoning stipulations for that property. Section 134-230 as well as 134-231. We talked a good bit today about freestanding climate-controlled self-storage facilities. Both of these are allowed in the O&I as well as the NRC districts as a SLUP. They have been allowed in the light industrial as well as heavy industrial districts as a SLUP also. But in the industrial districts, Those standards were provided in section 134-279. So what's being proposed here is that we will ultimately remove 134-279 and put the requirements specific to freestanding climate control self-storage facilities in the light industrial and heavy industrial district regulations. So the codes that have been transferred over here mirror the standards for the O&I and also NRC zoning districts. We did have discussion, and at the recommendation of Planning Commissioner Dance today, there was some discussion about, rather than specifying that these are the minimum standards, because some of these standards are actually maximums, that we would possibly look to clarify that to say the following standards for freestanding climate-controlled self-storage facilities. And so that would include standards such as maximum building height, floor area ratio, access architecture, the requirements to submit a landscaping plan, screening of the detention and loading areas, also having the Board of Commissioners to set the hours of operation for the facility based on the surrounding uses and the operating hours for the other nearby uses. It would also prohibit outside overnight storage, long-term storage of heavy equipment, parking of construction vehicles and equipment, prohibit storage of recreational vehicles and boats without adequate screening, and then would prohibit storage of flammable liquids, highly combustible or explosive materials, and also hazardous materials. And this would still require a special land use permit in both the light industrial as well as heavy industrial districts, so it is something that would still require consideration by the Planning Commission as well as approval by the Board of Commissioners. Section 134-272. This all pertains to traffic and parking. The first change is to clarify the curb cut requirements for districts other than the residential districts. As you all know, we have several documents here in Cobb County that regulate development. We have the zoning ordinance. We also have the development standards, design guidelines. This standard for curb cuts is something that is addressed in the development standards. So taking the requirement out of the zoning ordinance just to reference county requirements, the current county requirements, and then of course that would be the development standards where that's most appropriate. Also clarifying the process for approval of entrances and exits on state highways. As you all know, entrances and exits onto state highways are reviewed and permitted by the Georgia Department of Transportation. The way that the code currently reads, we would have to issue a permit within 30 days. We have no control over how long Georgia State DOT takes to review an application for an entrance or exit on the state highway, so it's appropriate to take that limitation off of the county because that is not a county function. We also have a standard in there that would prohibit perpendicular parking on a public road, but allows for approval of parallel parking by the Department of Transportation. And then the final change in section 134-272 is one that was discussed a couple of years ago. That would allow for parking on a non-hardened surface in residential districts with larger lots larger than 5 acres. This is something that comes up frequently on larger residential properties where there is a desire to have a gravel driveway or some other surface that's not a hardened or treated surface. It's something that on a larger lot certainly does warrant more consideration, and it frequently comes to the Board of Zoning Appeals for consideration for a variance, and typically is approved with no issue. So as proposed, it would allow for non-hardened surfaces for lots larger than 5 acres, but would allow for no vehicles to be parked within 50 feet of the right-of-way unless they have except on a treated or hardened surface. And then, of course, would also require a 25-foot paved or asphalt apron at the public road, which is typically the requirement that DOT asks us to include whenever those variances are approved. The next one is another commissioner-sponsored proposal. This is 134-275.1 pertaining to the Military Airport Hazard District. Of course, this applies to the properties around the Dobbins Air Force Base area. Currently, the code specifies a number of land uses that are incompatible in the accident potential zone surrounding the runway there at Dobbins. There was an amendment to that code that was made in, I believe, 2018 that allows the Board of Commissioners to have some additional consideration to allow some land uses that otherwise wouldn't be allowable in the APZ areas based on some other factors such as adjoining uses, historical uses, and height. And, it can really be considered on a case-by-case basis. And the request that's being made here and what's been proposed by the commissioner is to remove that leeway that the code currently grants the Board of Commissioners to really be a little bit more stringent in applying or sticking to the land use restrictions there. We also had a lot of great discussion in the work session about this item, and Commissioner Dance recommended some changes to that section. There was item 4, permitted uses, and number 5 there. Currently, the way the code reads, it puts the onus to notify an applicant for a building permit, rezoning, SLUP, all of those things, that the property is in the APZ area on the Community Development Department. And Commissioner Dance suggested at the work session today that really the applicant should be responsible for knowing that their property is in the APZ area, and they should notify the Community Development Department or Community Development Agency. So that's something that certainly we can consider, and as we discussed in the work session today, if the Planning Commission would like to recommend that we make that change, then we can incorporate that as it moves forward to the Board of Commissioners as a Planning Commission recommendation. Again, 134-279, I already mentioned this, just removing the language pertaining to self-service storage facilities, because that now is incorporated in the LI and HI district regulations, just as it previously has been with the ONI and NRC districts. 134-290, again, just a little cleanup item. Currently, it reads backyard chickens under 80,000 square feet. There was some conflict in the code where in some places it says 80,000 square feet, in some places it says 2 acres. Well, there's about a 7,000 square foot difference between 80,000 square feet and 2 acres. So rather than backyard chickens under 80 square feet, it'll be backyard chickens under 2 acres, and clarifies that the lot size to have backyard chickens by right would be a minimum of 2 acres. And then our last amendments are all to the sign section of the sign code. 134-315, this pertains to non-residential uses on commercially zoned property, as well as non-residential uses on residential properties or apartments. So when we talk about non-residential uses on residential zone properties, that could be things such as churches, schools, all of those things that are allowable in the R districts, but are not truly single-family resident uses. So 315 would allow for 1 permanent sign per entrance and exit that's no more than 3 square feet, no more than 3 feet tall. That ultimately these are typically your entrance and exit signs, just directional signs, so to allow for that. We've also incorporated 134-323, again, specific to non-residential uses on residential properties and apartments. Currently, under the current code, then this all pertains to temporary signs here, 323. The current code doesn't allow for churches and some of those non-residential uses on the residential properties to have things like banners, that temporary signage. So this would allow a little bit more flexibility for them to have those, just as commercially zoned properties do, but it would prohibit some of the things that would otherwise be permitted on a commercially zoned property, such as searchlights and the inflatable devices. Those would not be allowed on those properties that are non-residential uses on residential zone properties, and also for apartments. And then also restricting inflatable advertising devices so that they are only allowable on roads with four or more lanes, and in the CAC and RAC areas, so require a permit, of course. That is the full scope of the amendments to Chapter 134 this year. And I will say, and as you're all aware, we are considering making a more comprehensive update to the zoning and development regulations for Cobb County. That's something that we are actively pursuing. The Board of Commissioners has allocated funding for that. That's a larger project. So as such, with that in mind, the amendments to the 134 this year are primarily cleanup items, and we do expect to take a much deeper look at the other items within the code. So just moving forward from here, the next steps, and for everyone's information, is that the amendments to Chapter 134 tonight, you all as the Planning Commission will hold a public hearing and give the folks here an opportunity to speak to those and to give feedback. Then, of course, you all will have the opportunity, just as you do with zoning, to make a recommendation to the Board of Commissioners through a motion and through a vote. You have the option, you can vote on the whole package together, or you can take it section by section. It sounds like there may be some changes that you all would like to consider recommending as part of the recommendation. So in that case, it may be most appropriate to take it section by section. After this evening, what happens next is the amendments to Chapter 134, as well as the amendments to the entirety of the code. So all of the sections, all the chapters that are outside of the purview of the Planning Commission will be heard by the Board of Commissioners at the first public hearing on January 25th, and that'll be the evening meeting. And again, opportunity for everyone to come out and give public comment on that. And then the second Board of Commissioners public hearing for these and all of the other code amendments would be on February 8th. And that would be the first opportunity that the board would have to vote to approve and to adopt the code amendments for this year. So with that, I would ask for the public hearing to be open. Of course, I'm glad to answer any questions that the Planning Commission may have. Thank you all.
Are there any questions before we go to the public hearing from any of the planning commissioners? Okay, no questions at this time. Thank you very much. And,
Thank you.
Council, are you going to make an announcement regarding the rules, or will ComDev make an announcement regarding the rules for the presentations by any individuals wishing to speak tonight?
Is it on? There you go. Any members of the public are allowed to participate in the public hearing. I believe they get 3 minutes to address this commission. We'll need them to sign in. We ask them to keep their topic to the Chapter 134 of the code as discussed by Director of Community Development.
Okay, so I see 5 people out there. So do we have 5 people signed up to speak, or? Okay, so just 4.
They don't need to sign up ahead of time.
Okay.
Yeah, but we ask them when they come up to sign in so we can keep a record.
All right, very well. Well, folks, please come up, approach, and come forward to speak. Please, when you come up, please identify yourself. If you're part of a civic group or HOA, please identify that, and please also tell us what specific code section you're commenting on. Thank you. Thanks. Okay.
Hello, y'all. I'm Ron Siphon. And apparently, the first issue I'm going to discuss was in Section 106-98.1 as well as 134-121, having to do with the traffic studies. And y'all all saw my email. So what I'd like, and I understand that y'all are considering reducing the 1,000 to 750, but I would bring to your attention that think about the traffic studies that y'all have reviewed and all the zoning cases that you've dealt with. Traffic studies address trips. The code amendment addresses trip ends. Now, what I've been told is that trip ends refers to destination trips at the property in question, as opposed to origination trips. So trip ends would therefore be half of all the trips. So if we are thinking in terms of 750 relative to 10 trips per day per home in a single-family neighborhood, trip ends is only 5 per day. So instead of 750, the equivalent number would need to be 375. Or, again, think about all of the traffic studies that you've read. They address trips. I don't know why we're using the term trip ends anyway. The even better idea would be 750 trips. We know what trips are. And if we're going to use the term trip ends, we need a definition of what trip ends means in the code. But I think the best answer, go with the 750, remove the word ends, because traffic studies address trips. You've all read traffic studies. They address trips, use the same terminology in the code as we have in the traffic studies. So that would be the best answer. 750 trips, remove the word ends. And then that would be satisfactory. I think that would get us to where I think we all agree that we need to wind up. So then on the next one, I'm sorry.
Mr. Chairman,
I would,
Mr. Chairman, time is almost up, but the board can give them extra time if they so desire.
My fellow planning commissioners, is there any willingness to listen for another minute or so here? Grant the speaker another minute. Can we agree to that? Let's just can we call it a motion? Call it a second by Commissioner Vaught. All right. And by a vote of 5-0, we've agreed to extend the speaking time by a minute. Thank you.
Thank you. And I addressed the second issue that I had emailed you about, not the first one. The first one had to do with overruling DOT decisions that had been adopted into a zoning decision. I think that's problematic for the reasons that I emailed you about. And on section 134-230, I think the correct wording should be no more, an FAR of no more than 1.0, as opposed to requiring the FAR to be exactly 1.0. So thank you.
Thank you. Thank you very much. Who's our next speaker tonight?
You can sign in on the way back.
Thank you. Good evening, Commissioners. My name is Teresa Stendahl, residing at 5850 Altree Church Road, Ackworth, for 48 years. In reading the code amendments for section 134, 230, and 231, I really don't know what to say, except for the fact that while I understand the explanation given as to why there seems to be a need for conformity, when you're looking at LI and HI property, while it does address in the code that it's the LI and HI district, we do have some HI parcels of land throughout Cobb County, and I can only speak to one in particular that's within a couple of miles of where I live, for which we have had a rather contentious BZA hearing this past year for a gentleman who wanted to put in a 3-story self-storage facility on a residential road surrounded by R30 property. And in looking at this proposal for the changes to totally eliminate 134-279, I just don't understand, I'll be honest. I don't understand, because all of the protections that are in 134-279 seem to have vanished. If you're deleting that code section, I don't see it replaced in like kind when you have a unique property that might have had a spot zoning decades ago that someone, yes, can come in and put in a self-storage facility, but yet you're surrounded by residential properties. So I would respectfully request, number one, that there be more clarity as to what the real intent is of the county. There are some parcels, like where I live, that are just not uniform relative to the county. We are a unique area up at the Lake Allatoona corridor, but it also means that development in that corridor needs to be very, very geared toward the protection of Lake Allatoona, among other things, and adhere with the Northwest Vulnerability Study. So I would respectfully request that this particular code amendment, the 134, 230, and 231, be taken out of this package until there can be some further discussion and possibly some clarity with those of us who have a unique situation that would not fit into this county code. Thank you.
Thank you very much. Who's our next speaker?
Hi, Greg Lowry, live at 5092 Gwendolyn Court, Ackworth. Have the same concerns as Ms. Stendahl. And looking at the code changes, I seem to eliminate a lot of the specifics that are in the original code that are there today. Some of the same variances that were requested earlier are completely missing from what would be the new code. That's very concerning. I don't understand it. The height of the building, the setbacks, there's just multiple changes there, and it's like they're all gone. So same concern, same code change. It just doesn't seem appropriate. So I'd just like to request that that be reviewed and possibly changed or removed. It just doesn't seem to make sense. So that's it.
Thank you. Do we have a fourth speaker tonight? No. Okay. So that closes the public comment portion of the meeting. Is that correct? All right. Thank you. In that case, is there comment back from the county?
Yes. First of all, to Mr. Siphon's point about trips versus trip-ins, and as I shared with him before, the information that we have, the numbers that we have were provided by the DOT Director, Drew Ressler. I understand his point about trips versus trip-ins, and I think that what we can do from here is I'll be happy to talk with Drew to clarify that trip-ins would be, or trips would be adequate language to see if that works for them, if it achieves the goal. And so I think we know what the goal is here. To be sure, especially if you all are looking at changing the 750 and 75. I think I understand the goal, so if it's okay with the Planning Commission, then I would be glad to go back and talk with DOT and make sure that we've got the right language to achieve that goal before it goes to the Board of Commissioners and to have that clarified, trip-ins versus trips. If it's okay with him to just say trips, if it's okay with Drew and DOT says that makes sense and it's appropriate, then we can change that language. To the other points about the self-storage facilities, and as discussed in the work session today, the standards that are being proposed in the LI and the high industrial or heavy industrial districts are word for word what's provided in the O&I and also the NRC. I understand their concerns. I recognize that there's a lot of history there, and history that frankly I haven't been a part of even. One possible option here is if the Planning Commission would like for us to take a step back and go back and work with some of the residents who have come this evening to share their concerns. Something the Planning Commission's done in the past on some of these items is to hold it to February to give us time to talk with the residents and see if there are some changes that need to be made there that are appropriate. We would still move forward with the Board of Commissioners public hearing on January 25th, the first hearing. But of course, the Board of Commissioners doesn't vote then. So what we've done in the past is to take it forward to the Board of Commissioners, and we say, hey, this is something the Planning Commission has held. They heard it, and they've held it to the February meeting. And then if we can achieve a good solution by the February meeting, and you all are ready to move it forward, the February meeting for the Planning Commission is February 1st. The Board of Commissioners' second public hearing is February 8th and adoption. So at that point, if it's ready to move forward and the Planning Commission's ready to move it forward, we'll move it forward at that time to the Board of Commissioners. If the Planning Commission still feels like it's not ready to be moved forward to the Board of Commissioners, then at the February 8th hearing with the Board of Commissioners, we would tell them the Planning Commission has held this again and that we're still working on it, and then the Board of Commissioners could hold it if that was their desire. So we still have opportunity if the Planning Commission would like us to take some time to talk with the residents about it, those are the options there.
Anything else? Just here to
Any
answer
other-
any questions any of the other planning commissioners have.
Absolutely.
Any
Yes.
questions at this time before we start moving through these on a one-by-one basis? No? Okay. Yes, sir.
I just had one question so would the scope of those discussions be around updates specifically to this section or kind of reconciling NRC and O&I language? So just want to understand kind of what the scope,
It
if
would
it's-
be
if it's specific
specific
this.
to the LI and the HI districts that are included, and then the removal of the section that's been proposed for removal. So it would be only the things that have been advertised. So we wouldn't delve into the O&I and the NRC because
Okay.
those are not sections that have been advertised for amendment at this point.
Got it.
So we would stick with the sections that have been advertised for amendment. So it would be the light industrial, the heavy industrial, and then the removal of, I have to look at the section that currently addresses it with the standards that were referenced by the.
279. Okay.
Yeah,
Perfect.
yeah,
Okay,
279.
great. Thank you, Jeff.
All right.
All right, then, let's go then to the first section, the definition section. Does any commissioner wish to speak regarding any concerns, thoughts regarding the definitions?
Chair, would it be helpful if we had the slides up here for your reference?
Certainly.
Pertaining, yeah. So I'll go to start at the beginning, and that way you can have a quick reference for those items in each section. There we go, 134.
So 134.1, if there's no discussion, is there a motion?
I move for adoption, as stated.
Okay, motion by Commissioner Vaught for adoption.
Second.
Second by Commissioner Planning
May
Commissioner
I
Anderson.
ask for clarification?
Yes,
Move for adoption as a recommendation. Is that-
yes, we're simply making a recommendation that the board adopt this particular.
Mr. Chairman, I would recommend the language be moved to recommend as presented, recommend approval as presented if there are no changes to any of the language.
Very well. So we can take it that the motion is to recommend as presented. Is that correct? That was your motion, and the second still applies?
Second still applies.
All right, call the question. All right, so ComDev's proposed 134.1. As we have moved to recommend it as presented. Okay, let's move on to 134-7. That was your deletion of certain existing poultry language, correct? Is there any discussion regarding this, or if not, I'll entertain a motion on that.
I move to recommend approval as presented.
All right.
Second.
We have a motion by Commissioner Dance and a second by Commissioner Hughes. Any discussion? Call the question. And that also is recommended as presented by a vote of 5-0. Okay. Moving on, we have 134-121. Can you throw that up there? When traffic studies. So the request from from a member of the public was that we modify this to restate the number 1,000 to the number 750, and to delete the word ends, and to change the word 100 to 75. That was the request from the public. Is there a motion to either adopt as written or to or to adopt as modified, or otherwise.
Discussion.
Can we, yeah,
Discussion, yes.
It seems to me that the question was eliminating the word trip ends, and I'm a little concerned about changing ends without the benefit of professional staffs weighing in on that. So I'm not sure how the rest of the commissioners feel about that, but I would like to defer to the professional staff who have experience.
Commissioner Dance, we'll just,
Yeah, so my recommendation would be that we request that professional staff provide input as to what's appropriate in that section.
Commissioner Vaught?
and I was going to say something a little different. I definitely agree that professional staff needs to clarify ends versus trips, but I do think we should entertain a motion to recommend the necessary changes from 1,000 vehicles to 750 and from the 100 vehicle language to 75.
Commissioner Anderson?
Just to clarify, is this something that similarly can be held and then considered for prior potentially to the February 8th meeting as well?
It certainly is something that you could, a couple of options. You could hold it and we could get that clarification and present it again at the February meeting of the Planning Commission. Another option, if the Planning Commission was comfortable with it, is that we could go ahead and modify the language here to say trips with the stipulation that community development staff will clarify with the DOT staff that that is appropriate to achieve the goals here. Whichever option is preferable to the Planning Commission works just fine, though.
Right.
I'll let any one of you make a motion at this point.
Oh, sorry, go ahead, Commissioner. Just from discussion perspective, I think it makes sense to hold this. It seems as, a potentially 2x swing in what actually is the governing amount of trips or trip ends would be pretty significant. So I'd prefer to at least have the clarification from professional staff as well. The only question I would have is that there doesn't seem to be any kind of concern as stated with some of the other recommendations, particularly around the 30-day requirement. Is there an opportunity to partially approve, or is it something where this needs to be holistically approved as one bucket of changes?
I think it's cleaner to move it forward as one bucket of changes. Again, we have the opportunity. There's still another Planning Commission meeting before the Board of Commissioners will vote on this. So you do have that opportunity to, and it should be, I would imagine, a pretty quick, yep, here we are, here's where we net it out at the next Planning Commission. I don't think it would be a lengthy discussion. So if it were up to me, I would prefer just to move this section as one piece, and we can get that clarification between now and February, no problem.
Got it. Thank you, Jessica.
Okay, we have a motion. Is there a second?
What's the motion?
The motion is to cancel as hold or continue the correct term in the context.
Since there has been a public hearing and debate, it would be continue, if that's the preference of this
Right. So
commission.
the motion is continue our consideration and recommendation on section 134, 121 until our next meeting.
So, subject to the input of professional staff.
Yes. So we have, is that a second?
Second.
Second from Commissioner Dance with a comment that we look forward to the input of professional staff on that point as to whether the word ends can be deleted to accomplish the objective.
As well as the numbers.
Yes, that would be helpful on the numbers as well, since we didn't. Folks out there, what they don't know, we were busy texting folks from the DOT last night. They'll probably be there at the next meeting, so we'll perhaps have a chance to hear from them directly.
And with regard to the numbers, the 750 and 75, I have already emailed Drew and just let him know that may be something that was being considered, and he said that they could work with that. That would be fine.
Thank you. Okay, so we have a motion and a second. Is there any further discussion?
I'll just have one discussion.
Yes, sir.
Or just to make sure that it's, for the record, is that, but I'm in full support of the motion, but it really is tending to something that you said, and I want to make sure we state that obvious, is that we're trying to achieve a goal that having these traffic studies is a good thing and gives us an opportunity to have more facts to make better and more informed decisions. And so we want professional staff to come back after their review with our goal in mind and make sure we're supporting that.
Yet for certain very small projects,
Yes.
relieving somebody of the burden
Absolutely.
is fine. Very good, excellent point. So we have a motion and a second. Call the question. All right, so we move by a vote of 5-0 to hold our recommendation on Section 134, 121, and to consider the matter again in February. All right. Unless I've skipped something, 134, 120, yes, you've got it up, thanks. That's fine, that was a recommendation of the county attorney's office, correct? So do we have a motion? Well, I'm sorry, I'm jumping the gun. Is there any requests for discussion? Anyone want discussion on this? Okay. Is there a motion?
I move that we recommend as presented.
All right. We have a motion from Commissioner Vaught to recommend as presented the proposed Section 134, 127.
Second?
And then a second by Commissioner Anderson. Any further discussion? Call the question. All right, so by a vote of 5-0, we recommend the adoption of the proposed code amendment as written. Next code section is 134, they're all 134, but 134, 162, allowing for acceptance of applications for RA6 zoning. Any need for any request for further discussion on the point? All right, call the question. Or no, I'm sorry, can't call the question. Is there a motion?
Move to approve as presented.
Thank you. Planning Commissioner Hughes has moved to approve as presented. Is there a second?
I'll second.
Second from Commissioner Vaught. Call the question. All right, that passes by a vote of 5-0. When I say passes, that is our recommendation to the Board of Commissioners is to approve this as written. Next is 134-203.2. Is there any discussion on this? Okay, I had a question. What would currently be allowable on a collector road?
Well, this is specified in another section. So RSL, the way that the RSL is split up in the code, there's an RSL section, an RSL supportive section, and an RSL non-supportive section. So the RSL section calls for this, but that's not currently what's in the RSL non-supportive section. So there's it's a little discrepancy, I suppose, in the code.
So RSL supportive would already be this, is what you're saying?
Yes, to my knowledge, yes. And
Okay.
I hate John's not here. He's a lot better versed in the RSL code than I am.
What would non-supportive be?
So supportive is, whenever you talk about non-supportive RSL, that's
Right. Senior,
So are you asking-
55 and older, right?
but the supportive has the services, whereas non-supportive does not have all the services that would come with senior living, whether it's care, assistance, more of an assisted living versus independent.
Okay, but I'm just focused on the density maximum, really.
Right.
10 acres seems to be decent-sized project. Is that a downward adjustment, though, of the minimum currently required?
No, okay, so, right, so currently, the way that it's written currently, it does not allow for, or there's no provision in 134-203.2 to allow for a non-supportive project on a collector road. So this would open that up, or, again, clarify what's in another part of the code, that you would be able to do it on a collector road, so long as it's a property that's of a decent size, the 10 acres, with the lower density, the maximum density being 4 units an acre. Does that answer your question?
Pretty much. So you're saying right now, you're not really supposed to have RSL on a collector road? So this is a liberalization of where RSLs can go?
You can have an RSL on a collector road if it's 10 acres with a maximum of 4 units per acre. But again, there are 3 sections of code pertaining to RSL. So there's the RSL code that does specify you can have RSL on a collector road as long as it's 10 acres and no more than 4 units per acre. But then it also splits it up in the code to, well, here's the code for supportive and here's the code for non-supportive. And this is an instance where what's in the overall overreaching RSL code hasn't been carried over to the non-supportive category.
Do any of my fellow commissioners have any questions?
I thought I read it in actually the code as published online, the language already there, where it says a non-supportive RSL may only be located on a collector road if the following criteria is met: a minimum of 10 acres and a density maximum of 4 units per acre. I guess that's what I see now on the RSL non-supportive residential section on the Muni code that's published. So I guess.
So what does Muni code say? I'm sorry.
It says actually it already has this language.
Right.
So
What section is that in, though?
134-203.2.
Okay, let me pull up my. And as we look at our codes, I think the 3 sections of codes regulating RSL is something that we probably need to clarify and make it a little bit less confusing.
Yeah, the only reason I mention it is because I don't see it in the just general 203 just 203 section, the regular RSL supportive. What?
I'm pulling it up right now.
Yeah, 203.1. So I don't know if they're backwards or I'm probably just missing something here, but 203.1 doesn't have it on the Muni code.
203.1, you said does not have it?
It doesn't seem to.
Okay, hold on.
And that pertains to?
The language here. So this language is actually is written in 203.2 on the code, already there, but it's missing from 203.1.
No, it's in 203.2. If you look at item N, it does not include it.
Well, I'm just looking at the purpose and intent section.
Right, so this is the piece that's being changed, though, is N, so.
Oh.
Okay, so here it is, and you're exactly right. It's in the purpose and intent, so ultimately, this is going to clear up that discrepancy, because N right now, if you scroll down to N, it only says along an arterial roadway. So this would add in there to be consistent with the purpose and intent or a collector.
Okay.
If it meets those standards. So that's where
Got it, okay.
our powers combined.
Okay, good. But there was the intention wasn't to add this language to 203.1 in a purpose and intent section for that either. This is strictly
for
for 203.2, it's a non-supportive.
203.2, that's correct.
Okay, got it. Thank you for clarifying that.
Thank you.
But you're suggesting this change is really just clarifying, and it's not a substantive change to the provision?
Right, it's not, and the point here where if you look at 203.2, and that's a great point, Commissioner Anderson, you look at 203.2, Item 1, purpose and intent, it does say a non-supportive RSL may only be located on a collector road if the following criteria is met: minimum 10 acres, maximum density of 4 acres, 4 units per acre. But then when you scroll on down, you get to N, there it just says it's got to be on an arterial roadway. So it's not consistent even within that section. There's inconsistency in that section.
Got it.
Anything?
No, I think that
Cover.
clarifies my question. I was just a little confused, but you clarified. This reconciles that.
Right.
Any
So
other,
thank you.
Any other planning commissioner questions or comments? All right, any motions?
Recommend approval as presented.
Motion by Commissioner Hughes to recommend approval as presented.
Second.
Second by Planning Commissioner Dance. Any further discussion? Hearing none, call the question. That motion carries by a vote of 5-0. All right, you're going to tell me what code section we're going to next. Are you already there?
Already there.
All right, we had a lot of discussion about this one too, and since there was a lot of my understanding is the idea emanated from the district commissioner for District 3, so Commissioner Dance had some ideas, and Planning Commissioner Dance had some ideas during our discussion. So would you like to comment at this time about that, or?
I'd like to just go ahead and make a motion, and then we can follow up if that'll work.
That's fine.
Okay, so I would move to approve the deletion of the ROD in 134-221.2 with the recommendation for consultation to occur with the county attorney regarding how to ensure the continued applicability of the ROD to any property previously zoned as a ROD prior to the effective date of deletion.
Okay. So we have a motion.
Second.
There's a second by Planning Commissioner Hughes. Any further discussion? All right, call the question. The motion carries by a vote of 5-0. 230, light industrial. And as to 230 and 231, there was a suggestion from staff that perhaps this could be something where they met with the folks in the community who had objections to this, and we could consider this in February. But again, I'll entertain any motions, or if anyone has questions for the community development, we can start there. Planning Commissioner Vaught.
I don't have a motion. Thank you, Chairman. I was going to, per some of our work session discussions, and given the fact that it was presented that community development could have some of these discussions with the concerned citizens, I think it may be prudent to talk about some of our discussion or what we talked about, so that could be included in any discussions going forward.
Certainly.
And so I know Commissioner Dance had mentioned around this, the wording around minimum standards, and saying about taking out the word minimum, so that we could just talk about those standards that should apply to the freestanding climate control self-storage unit.
Okay. Any other suggestions for staff for further consideration? I guess you had the comments from the public. I think I saw one comment regarding FAR, and then you had two comments regarding whether this was an attempt to essentially change the laws with respect a specific case or two that came before the BZA in the past couple of years. So any other comments or questions? Planning Commissioner Dance?
So I think what we were discussing after public comment was actually looking at considering 134-279 and its deletion along with 134-230 and 134-231.
Correct?
Is that right?
Yes.
Okay.
So do you have a motion regarding all three?
I would move that we would continue consideration of 134-230, 134-231, and the deletion of 134-279 to allow community development to work with the residents in the area regarding their concerns, specifically of the deletion of 279, and to try to reconcile any concerns and bring forward a recommendation at our next consideration before the PC.
Okay, we have a motion. Is there a second?
Second.
Second by Planning Commissioner Hughes. They beat everybody to the button. Okay. Any further discussion? All right, call the question. That motion carries by a vote of 5-0. Where are we next? Traffic and
272.
parking. 134-272. And Planning Commissioner Hughes had a comment during our meeting. Would you like to share your thoughts publicly on that?
No, this was just, I think, community development. Gwen talked earlier about the Unified Development Code and where you guys are moving forward with that. As I was reading this section, it occurred to me that a lot of the items in this section probably should be considered for putting in the development standards. So that's just something to think about as y'all are moving forward on that project.
Does that temper your thoughts on what we should do with this at this time?
No, not at this time.
Okay.
Knowing that project is coming forward at some point, I'm sure staff will take a look at that.
Is there a motion regarding this proposed revision?
I make a motion to recommend adoption as presented.
Okay, we have a motion. Is there a second?
I'll second.
Second by Planning Commissioner Vaught. Is there any discussion? All right, call the question. Okay, that motion also carries by a vote of 5-0. $275.1. Okay, there was a fair amount of discussion about this. Any comments from any planning commissioners on this or questions? All right, any motions regarding 134-275.1?
I would make a motion to approve the language that is suggested or recommended and on our printed sheet, but also to recommend a change to the code section 134-275.1 with respect to subparagraph 4, item 5, about to place the burden on the applicant to acknowledge the applicability of APZ 1, APZ 2, or a clear zone at the time of application.
Okay. So we have a motion, as I understand it, to approve the recommendation is written with supplemental language requiring that an applicant disclose in its application whether any portion of the subject property falls within any APZ 1 or APZ 2, and as I understand it, APZ, if I recall, stands for Accident Potential Zone. Is that correct?
Yes.
Okay. All right, so that's the motion. Is there a second?
Second.
Second by Planning Commissioner Hughes. Is there any discussion? No discussion. I'll call the question. So that motion carries by a vote of 5-0 as well. Ah, backyard chickens. Profound sense of deja vu, but we're back to backyard chickens. Okay. Any discussion from any planning commissioner or any questions regarding the backyard chicken ordinance proposal contained within 290? Any motion respecting it?
I make a motion to recommend adoption as presented.
Okay. Planning Commissioner Anderson has moved for to recommend the adoption of Section 134-290 as proposed by Community Development.
I'll second.
Commissioner Vaught seconds that. Any discussion? Call the question. That motion carries by a vote of 5-0. We're on to our signs.
So for signs, there are two sections. There's 134-315 and 134-323.
Right? Okay. Is there a motion?
If there are no objections, I'll make a motion to approve both articles pertaining to signs 134-315 and 134-323 as recommended for adoption as presented.
Okay, we have a motion to adopt these two sections as presented. Is there a
Second.
We have a second from Planning Commissioner Hughes. Any discussion? Call the question. And that motion passes by a vote of 5-0 as well. With absolutely no adverse inference whatsoever cast on all the inflatables that have been put up in the Christmas season by our friends. Okay. Does that conclude our?
That concludes our agenda for the evening. Thanks to each of you for taking the time to review the code amendments ahead of time and coming in with thoughtful questions and comments, and for your work on this afternoon. We really appreciate it. Thanks.
Okay, thank you very much. And look forward to working through this again a little bit next month. And council, we had a discussion during the work session whether we could appropriately entertain a vote for a successor chair to this committee.
Well, the code
This group.
This planning commission can elect a chairman at least annually or till successors needed. We had discussed in December about doing so at this meeting, this hearing in January. It was not advertised that way on the agenda, but we can amend the agenda to include that since we have already discussed that. That would be at the discretion of this body, though.
Okay. Can I entertain a motion then to amend the agenda to elect a new chair and is it vice chair or secretary? What's the title?
I believe it's vice chairman.
Okay. Thank you.
So moved.
Okay. I have a motion from Planning Commissioner Dance to amend the agenda to allow that. Is there a second? Second by Planning Commissioner Hughes. Call the question. That motion carries by a vote of 5-0. Is there a motion to nominate any one of you to be chair of this group?
I move to nominate Stephen Vault to be chair.
Okay, we have a motion to nominate Stephen Vaught as chair.
Second.
We have a second from Planning Commissioner Hughes. Is there any discussion regarding this? Is there any request by anyone to nominate anyone else for the position? Do we have to formally move to close the nominations, or can we simply move to a vote?
I think you just move to a vote.
Very good. Call the question. Okay, that motion passes by a vote of 5-0. Is there a motion for is there a motion or recommendation for a vice chair or a nomination?
I move to appoint Michael Hughes as vice chair.
Okay, there's a motion.
Second.
There's a second by Planning Commissioner Anderson. Is there any request for discussion or any request by anyone to nominate anyone else? All right, then in that case, we'll consider the nominations closed and we'll call the question. That motion also carries by a vote of 5-0. So I want to thank everybody that spoke in front of me for the last 7 months and addressed themselves to me. It was very, very kind of you to do so, and it's been a great privilege to be the chair of this group for a few months, and I very much look forward to our new leadership, and I very much look forward to and hope to continue to serve with this excellent group of individuals. Thank you. And with that, do we need a motion to adjourn at this time? Would that be appropriate?
So move, Chairman.
Motion by Vice Chair Hughes.
Second.
I guess technically that goes into effect. That goes into effect next month. But motion by Planning Commissioner Hughes, second by Planning Commissioner Vaught. I'll go ahead and call the question. And by a vote of 5-0, that also passes. Thanks to everyone for your input tonight.